Getting sued for posting a photo of your own face that someone took without asking? Sounds absurd, but this has happened to celebrities like Gigi Hadid, Ariana Grande, Justin Bieber, and more. How is this even allowed, you're wondering? Let's dive right in. Ariana Grande posted a photo of herself covering her face with a bag. The photograph existed in the first place because she did not want to be clicked. She was sued and the case settled privately. Justin Bieber has faced multiple copyright claims for reposting paparazzi photos. Some were dropped, some were settled. A photographer sued Gigi for posting a paparazzi image of herself. She argued she contributed creatively by posing for the photograph, and so she had joint authorship. Courts rejected that theory. Why? Because posing is not enough to be considered the author of the photograph. This case, however, was dismissed for a technical reason. The photographer had not properly registered the copyright before filing. Dismissal does not mean she was legally correct, but that the lawsuit had procedural flaws. The pattern is consistent. Photographers assert copyright ownership. Celebrities either settle or fight technical issues. To understand why this happens, we need to separate two completely different legal rights. Under U.S. copyright law, the creator of an original work automatically owns it. The moment a photographer presses the shutter, they own the copyright. No contract and no permission from the subject required. Ownership exists instantly. Registration is not required for ownership. It is only required if they want to file a lawsuit in federal court. Legally speaking, the protected work is not your face. The protected work is the photograph, the creative expression. Courts recognize photography as creative because it involves timing, framing, lighting, angle, composition, even candid paparazzi shots qualify. Copyright protects the author of a work. It does not protect the subject. If you're in a movie, you don't own the movie. If you're in a song, you don't own the recording unless you created it. If you're in a photograph, you don't own the photograph. It feels counterintuitive, but identity and authorship are legally separate. Celebrities do have something called the right of publicity. This protects against using someone's likeness to sell products without permission. For example, a company can't put your face on a cereal box without your consent. But the right of publicity does not override copyright ownership. If a photographer takes a picture of a celebrity in public, the photographer owns the image. A newspaper can publish it for editorial purposes. That's protected speech. If the celebrity reposts that image to promote their brand, now they are using someone else's copyrighted work for commercial benefit. That's where lawsuits happen. Fair use allows limited use of copyrighted material without permission. Courts consider 4 factors: purpose and character of use, nature of the work, amount used, effect on market value. When a celebrity reposts the entire image, they're using 100% of the work, and they may harm the licensing market. That weakens fair use. If they were criticizing the photo, analyzing it, or transforming it, fair use would be stronger. Simply reposting makes for a weak defense. Some celebrities have argued, if I posed for the camera, I implicitly gave myself permission to use the image. Courts have generally rejected this. Why? Because posing does not transfer copyright. Unless there is an explicit contract, ownership stays with the photographer. The law is structured around protecting creative works, encouraging photographers, maintaining licensing markets. If courts ruled that the subject automatically had rights, photo licensing markets would collapse. Celebrities could repost freely. Media value would decline. So the system protects the creator of the work, not the subject. So what can celebrities do to challenge this? 1. Failure to register copyright. Under U.S. law, a photographer must register the copyright before filing a lawsuit in federal court. But this is a technical victory, not a ruling that celebrities own their photos. 2. Lack of originality. Copyright only protects original works. If a photo is so basic that it lacks minimal creativity, it might not qualify. But courts set the originality bar very low. Even simple choices like angle, lighting, timing are usually enough, so this defense almost never works. 3. Fair use. If a celebrity reposts the entire image unchanged, that's a problem. But a celebrity could strengthen fair use if they transform the image significantly, use it for commentary or criticism, mock or parody the photo, or annotate or analyze it. For example, if a celebrity reposted a paparazzi image and wrote a detailed critique of invasive media culture, that's stronger than simply reposting it as aesthetic content. 4. Trespass or illegal conduct. If a photographer trespassed on private property, used a drone illegally, violated stalking laws, or broke anti-harassment statutes, then the photographer's conduct may undermine their legal position. For example, California has anti-paparazzi statutes that increase penalties for intrusive behavior. However, even here, the copyright might still technically exist. Illegal conduct does not automatically destroy copyright ownership. It just creates liability on the photographer's side. 5. Reasonable expectation of privacy. If a photo is taken inside a home, a hospital, a private event, or through long-lens surveillance, the celebrity may have privacy claims. Privacy law is separate from copyright. A celebrity could win a privacy lawsuit even if the photographer owns copyright. Most of these cases don't end in dramatic court rulings. They settle. For the photographer, litigation is expensive. They want licensing fees, not precedent. For the celebrity, legal fees may exceed damages, and public trials create bad headlines. So even if the law favors photographers structurally, in practice, money negotiations end it. This issue exposes a modern conflict. Traditional copyright law was built before social media. Today, everyone reposts images. Identity is monetized. Personal branding is commercial. The law hasn't fully evolved to reflect that shift. So for now, the person who clicks the shutter owns the image, even if the image is your own face. Do you think this is fair? Where do you think the balance should be? Protecting photographers or protecting identity? Let me know what you think in the comments. And if you enjoyed this video, make sure you like, subscribe, and turn on notifications. There are a lot more strange lawsuits we need to talk about.